Good afternoon, everyone, and welcome to today's Institute of Export and International Trade webinar on cloud computing and export controls. This is a webinar being run for the Institute's export control profession, and I'm delighted to see so many of our ECP members on the line today. My name is William Barnes-Graham, and I am the Senior Content Editor at the Institute, and I will be your host for this afternoon. Now, in 2020, we're all operating in the cloud in one way or another, and we're all used to storing and sharing important documents using it. However, much like exporting physical goods in the real world, sharing controlled software or technologies using the cloud comes with its own risks and regulatory requirements. Thankfully, we have an expert in the field to guide us through these risks and obligations in Richard Tauwhare. Richard is a former UK diplomat with over 40 years experience in promoting and regulating UK exports. He also has experience negotiating international trade agreements and in designing and implementing sanctions and embargoes. He is currently an independent consultant and advising on international trade issues, including export controls. And before we hear from Richard, we will also hear from Roger Arfi, the chairperson of the Institute's export control profession, who will be briefly talking about the support we provide to people working in this space. But before handing over to Roger, on the next slide, you will see a poll which I'm going to launch now. And this poll asks, are you using cloud services to store or transfer military or dual use technology? The options are yes, no, not sure. Now, while people are answering that poll, Roger, delighted you've been able to join us again. To set a bit of context, why are webinars such as this one today so important for people working in this sector?
Webinars, good afternoon, William. Thanks for inviting us along. Yes, webinars are a great way of sharing information, much more personal and immediate than reading material in books or magazines, and also give the opportunity for interaction so that there's an opportunity to ask questions and get an answer sometimes in real time. So we look forward to hearing Richard's expertise, but also perhaps the opportunity to ask some penetrating questions and see what he can tell us about those.
Thank you, Roger. Just to now share the results of this poll. So 52% aren't currently using cloud services in this way, but 28% are, 20% not sure. Very interesting there. And just a couple of housekeeping notes before I hand over to Roger. Firstly, you can contact me with any comments or questions using the question panel on the control window to the right-hand side of your screen. And secondly, you will be receiving a copy of today's slide pack and recording of today's webinar later this week. So my recommendation is to really listen in to what Richard has to say. But to kick things off, over to you, Roger, on the next slide.
Thank you. Well, it gives me great pleasure again to introduce the export control profession, which is a professional body set up in the UK, especially for export control personnel. There's a lot of export control people around and increasing numbers. And so having a professional association to belong to is very valuable. The ECP was created and is led by export control specialists. We are a team of people from various walks of involved in export control in various ways, through academia, through industry, through regulatory organisations, and so on and so forth. The role of the export control profession is to promote professional development and professional recognition of export control staff. We support professional development through providing and supporting training and development opportunities. We have a very good continuous professional development program that's run by the Institute of Export that allows us to develop training and to keep track of our individual training scores. Recognised by post-nominal letters, you can become a member or an associate member of the organisation, and we provide resources to enable people to develop their skills, develop their knowledge, and also to enable increased compliance. And today's webinar is a really good example of the sort of resources that we are pleased to provide. Gives us the opportunity to explore new topics and develop ourselves individually and as an organisation. So thank you for joining us today. Very nice to see so many people joining in. And it gives me great pleasure to pass over to Richard Tauwhare, who's going to talk to us on the very important topic of cloud computing and how it affects export control, particularly sharing software and technology. So Richard, thank you very much. Welcome to the webinar, and we look forward to hearing from you.
Thank you very much indeed, Roger, and thanks to William and to the Institute for inviting me to present this webinar. And thank you to everyone who's participating and set aside some time this afternoon to listen in. So let me, without further ado, click along. We've got, I believe, until 3 o'clock, and I want to allow plenty of time for questions at the end. So William has already kindly introduced me, Richard Tauwhare, an independent consultant, and I advise on export control and sanctions issues across the UK, the EU, and in some respects US export controls as well, which, as I shall say, should not be forgotten. So let us look at the 4 headings that I'll be dividing the subject into this afternoon. The first one is, what is cloud computing? I'll keep that brief. I imagine most of you would already know broadly what we're talking about. Which regulations apply? What are the requirements? And I'm focusing essentially on actors who are located in the UK. So if you're located somewhere else, the rules could well be different because there is no sort of set of harmonized international requirements on this. And what are the best practices that I could advise you on? And again, this is just my opinion. As I put at the bottom there, you'll see, please don't rely upon what I'm going to say as legal advice. This is my opinion, my best effort at summarizing what the rules are as I understand them. But if you do need more specific advice, do come back to me or seek legal advice. So what is cloud computing? Well, essentially, the difference between cloud computing and private computing is that it uses shared resources to store, backup, share, and access not only technology, but also software. I won't run through the different types. You can see them on the screen. One point I would pick up on is that it's not just, of course, sharing and storing your own data, but it's also often a question of accessing software that is made available as a service over the cloud system. What is the risk? So when we're talking about export controls, the problem that we face is that by using a cloud service, a user's software or their technology could be either routed through or stored in a foreign country, often without your knowledge as a user. And because it's going to a foreign country, it could therefore become subject to export controls because in a sense it's moving out of the UK and into another country. And as a result, there was a risk of breaking the law by exporting it to someone who is located outside the UK. If you break the law, there is a risk of potentially heavy civil and criminal penalties. So that's very broadly and briefly what is cloud computing. Now, which regulations apply? So for cloud users in the UK, the main regulations to be aware of are the following. And I've divided these essentially between the UK, the EU and the US. So in the UK, all military and some dual use items are covered under what's called the Export Control Order 2008. So that's the legal basis on which these controls come. For the EU, most dual use items, until the end of the transition period on the 31st of December, most dual use items within the UK are still controlled by this EU dual use regulation. And essentially on the 1st of January next year, that regulation will be retained in UK law, and so it will continue to apply. I'll say a bit more about Brexit at the end of this presentation. And for the US, now the reason I'm mentioning US, I'm not talking about the US rules as they apply in the US or US rules as they apply to US persons. I'm talking about US rules as they apply to you and me sitting here in the UK. And one cannot overstress the importance of understanding how those US rules continue to apply to us, even though, if you like, we're not sitting in the US, and you would think we would not be covered by the US jurisdiction. Again, I'll say more about that, but the International Traffic in Arms regulations and the Export Administration regulations both continue to apply to US origin items and even to some non-US origin items when they're sitting here in the UK. Now, what software is controlled? I've put some broad definitions up there. Essentially for the software, if it's dual use, it's software that's specially designed or modified for the development, the production or the use of an export controlled dual use good. If it's military, that military covers software that is specially designed or modified essentially for military use. There's some more detail there on the screen if you should need it, but the definitions are quite precise. And if, again, this might apply to you, you need to get legal advice or some expertise into deciding whether or not your particular software is controlled. The same rather goes for technology. Under the heading of dual use technology, the main definition given in the EU regulation is specific information that is necessary for the development, production or use of controlled goods or software. And that can take the form of technical assistance or technical data. And primarily what we're talking about today is technical data. I'll say more about that in a moment. For military technology, the broad definition is information that's required for these rather more extensive operations with respect to military goods or software. I put a little note at the bottom there that this is irrespective of the origin of the technology. So just because the technology might have been invented in, I don't know, France, and it happens to be sitting in the UK, doesn't mean to say that it's exempt from the UK regulations. The same applies to US technology, if you like. If it's US technology, but as long as it's located in the UK, then it becomes subject to UK controls. And moving it out of the UK, even if it was nothing to do with the UK, but it actually has come into the UK, when you send it out, it becomes subject to the UK controls. So what technology is controlled? So technology can take many possible forms, and I've listed them down there. So any of those, and those are not exclusive, there's other forms it can take as well. Really, you need to go back to that definition I showed you earlier of any information that is needed or is necessary for development, production, use, and so forth of controlled items. Any of that kind of information in any format constitutes technology. Now, what technology is not controlled? So there are certain exemptions, and the main ones I put on the screen. So I just mentioned these because it's important to be aware that certainly not all technology by any means is subject to control. So if it's in the public domain, and that essentially is defined as if it's available without restriction upon further dissemination except for copyright. So if you have to pay for it, you have to buy a book, then that doesn't, it still counts as being in the public domain. But essentially, if it's been published, then export controls no longer apply for other obvious reasons. If it's basic scientific research, again, we've got the definition up there. Sorry, there's a slight typo at the end. It's directed towards a specific practical aim. So essentially that would rule out pretty much any commercial purpose. So if you're doing research that has a commercial purpose and that would be become intellectual property and would be protected as intellectual property, then it's unlikely to be scientific research. Then the others exemptions are sort of rather more technical ones. If it's a minimum needed to install something that's already been authorized for export, or it's not controlled, or the minimum needed for a patent application. And to bear in mind, what I put up there applies to most military and dual use, but for nuclear technology, there are tougher controls for understandable reasons. We'll move on to a poll. So I'll hand back to William to take us through that.
Thank you, Richard. So going to launch the second poll now. Just bear with me 1 second. And this one is asking, do you currently have or think you need a license for controlled cloud software or technologies? And again, the options are yes, no, or not sure. And while people are answering that question, I'm going to ask a question for you, Richard. One we had in advance from Kerry, who's asked, regarding video conference security, is sharing sensitive information via WebEx or Microsoft Teams, or sharing a screen to view a document and export?
Yes, thanks, William, and thanks, Kerry, for the question. That's a good one. And I think the answer is essentially yes. If information is transferred via video conference, which constitutes technology as I've defined it earlier on, i.e. information required for development, production or use of controlled items, then yes, it would be controlled. The government is developing some updated guidance on technology transfers, which, as I'm going to mention, should be available later this year. And the draft of it addresses just this question. And it does make clear that particularly if you're using video conferences or Zoom or whatever other electronic communication method, the controls still apply if, in effect, the technology, i.e. the information required, as defined, is transferred outside of the UK. And that would clearly apply if the document or a controlled document itself was shown on screen. But it would also apply if the content of that document was read out such that the information that was conveyed over the video conference amounted to the people at the other end being able to put it together and thereby have received the information that is specifically necessary for the development, production or use of controlled items.
Thank you, Richard. So in a sense, we are in effect at the moment exporting this presentation if anyone's studying it from abroad, of it obviously uncontrolled.
Absolutely. Well, I think nothing I'm saying is subject to export control.
Let's hope not. Anyway, so the responses there, 39% said yes, 34% no, and 27% not sure. Any surprises there, Richard?
No, I don't think so. That's it's good to know, though. It's interesting how these things are developing.
Great. Thank
Okay.
you.
Thanks very much, William. Let's move along. So my third heading, what are the requirements? So I'll look at both sanctions and export controls. We normally focus on export controls, but I think it's important we don't ignore that sanctions can also apply to transfers of technology. So with respect to countries, there are restrictions to providing some internet-based services, software or technology to an embargo country. So certainly if it's a military item or an item that might be used for internal repression, certain financial services, those types of things can well be included in trade embargoes. So need to be taken into account as amongst the controls that apply to what can be transferred. And then to persons, by persons I mean natural persons, i.e. individuals, but also legal persons, that's organizations and companies. So restrictions apply to provision of internet-based services, software or technology that are made available to those sanctioned persons or to any entity that they own or control. So particularly if they are a UK denied party or a US specially designated national, for those individuals and entities, in broad terms, it's prohibited to provide them with any form of resource, and providing them with an internet-based service or software or technology of whatever sort would be prohibited. I mentioned there the US specially designated nationals because not only UK and EU measures would apply, but also US secondary sanctions are applicable to people operating in the UK. So that's sanctions. Now on export controls, as I'm going to sort of emphasize over the course of the next few slides, there is still some lack of clarity, I'm afraid, over the extent, the precise extent of the controls in the UK. A number of countries, notably the US, have recently taken steps to try to clarify specifically what is and what is not controlled. And the UK guidance that's under development should help to do that here as well. But for the time being, as I speak to you now, I'm going to have to hedge slightly what I say. So do take everything I say as being somewhat up in the air, and we will see exactly how it pans out when the new guidance is issued. But essentially, the way it works currently, and our current understanding is, as a license is required if you make controlled technology or software available to anyone who is physically located outside of the UK. And for the length of the transition period before the end of this year, that really means outside of the EU. So you can still make it available to someone within the EU until the end of this year. Now let me break that down somewhat. So first of all, what do we mean by make available? Apologies for the typo. So first, if you send a controlled item to a person outside the UK, so that includes a transfer by any electronic means, fax, email, phone, video conference, any of those would involve the sending, the transmission, the transfer of the technology outside the UK to someone outside of the UK that is making it available to them. The second means, which is perhaps more relevant to the cloud, is if you grant access to a person outside of the UK, either to read or to download the controlled item. Now, the licensing requirement essentially is determined by the location of the recipient and not the controlled item. So on that basis, uploading a controlled item, controlled technology or controlled software to cloud-based storage is not considered to be a licensable transfer or export, irrespective of whether the servers are in the UK or anywhere else, and irrespective of where it may be routed in the course of its transfer. So it may go on to several different servers and dotted around the world. That doesn't matter. It's not considered to be a licensable export. But, and this is part of the UK current guidance, users do need to take appropriate action to ensure that controlled technology that is uploaded to a server overseas is suitably protected. For example, using industry standard methods of encryption. But as I'll go on to say, in the UK, it's still not 100% clear that encryption in itself is considered a sufficient protection, and this remains subject to consideration. And contracts requiring the service provider, that's the cloud service provider, to control access to the technology on the servers. As far as UK servers go, the transfer of controlled technology from overseas into the UK, storage in the UK on a UK-based server, and then transferred out of the UK is not licensable in the UK, provided that the technology is not accessed or downloaded in the UK. So the way they're looking at this is, in effect, if you like, it's the mirror image of what I just said. If somebody in the US, for example, was to store their controlled technology on a server that was located in the UK, when they accessed that technology, when they were sitting in the US, in effect, that technology has been sent from the server in the UK across to the US, but it doesn't count as an export because it has not been accessed or downloaded in the UK. So in a tangible sense, it's never existed in the UK. Now, there are question marks over whether every other country applies a similar approach. So you might ask the question of whether if you save your information on a server, I don't know, in Australia, will the Australians require a license if you then transfer it out of Australia? I believe for Australia, at least, as an example, that they don't. They take the same position as the UK, but it's not guaranteed that every other country does. So this is an area, again, of ambiguity that it would help if the international regulatory authorities would help to clarify. Physically located outside the UK, what does this mean? So it's important to understand that the controls apply irrespective of who owns the server on which the item's made available. So it could be a server of your own company that's sitting in another country, doesn't matter. It could be a cloud service provider server, irrespective. And the nationality or employment status of the person overseas. So again, it's very important to understand that even if it's you yourself traveling, you go out of the UK and you go to the States, and then you open up your laptop and access material on your server in the company in the UK. That is accessing controlled data from outside the country. Just the fact that it's you, and even if you're only going to use it for your own personal use and not pass it on to anyone, that doesn't matter. The fact is you are not located in the UK, and therefore the action of accessing that data is licensable. And the same applies to staff of your subsidiaries or other members of the group in other countries. So you send it to your subsidiary in Singapore, they open it up, that's a transfer. Just because it's intra-company makes no difference. These are UK guidance. I think I mentioned Australia. I think the rules for Australia are somewhat more liberal, and they do allow individuals to open up information that is purely for their own use and which they've already had in their own country. So again, an area of divergence in terms of the regulations internationally. Who is the exporter? Essentially, this is the same as for physical items. It's the person who sends or grants access to a controlled item to a person located outside the UK. What this really means is it's the cloud user who has responsibility for licensing and not the cloud service provider. So that's the equivalent, if you like, of the freight forwarder or the shipper. In export controls of physical items, in general terms, the freight forwarder and the shipper is not responsible. It's the exporter, i.e. the company that owns the goods. But I should point out that a cloud service provider, if they are able and in a position to grant access to a controlled item, e.g. to one of their systems administrators, they would also be subject to a licensing obligation. It's also worth pointing out that cloud service providers who provide software as a service services, i.e. they make software available on their service for users to access, they're not conducting an export, since the user does not download the executable software themselves. So they're only making the use of software on a remote server, but they're not downloading the controlled software themselves. So that, in general terms, does not constitute an export that would be subject to licensing. When is a license required? So the timing of when a license is required, again, is not a precise science, but broadly, there's two possibilities. One is if the controlled software or technology is to be made accessible to a broad group of people overseas from the time that it is first uploaded or saved, then a license is needed before it is saved or uploaded. But if the upload happens and then afterwards individual permissions are required for employees or others to be given access to it, then it's only necessary to obtain a license before that permission is granted. Overseas export controls, again, this is another potential pitfall of transfers of technology and using cloud services. If UK controlled technology is sent to or is downloaded in another country, then the local export controls may require a license if that technology is then transferred back to the UK. So the example of that would be that you're on a visit and you're traveling and you're in the States, say, and you open up your laptop and you access your home server and open up some controlled documents. If you're only accessing them, you're reading them, and then they're not saved on your laptop, that's fine. You would then, when you left the US, you would not be exporting that technology. But if you saved it to your laptop, then it would be like sitting physically on your laptop. And when you leave the US, you would be exporting that technology. And in that circumstance, you would likely need a US export license. So to avoid that, best practice, best advice is that if you do download any controlled data or technology whilst you're overseas, you should delete it so that you don't require and there's no risk of you requiring an export license from the country that you happen to be in at the time. So finally, on to the last one. What are the best practices to try to ensure compliance with this rather complex and still somewhat ambiguous set of rules? So as far as sanctions go, ensuring compliance with the embargoes on countries, obviously you need to identify what is prohibited, what's licensable in terms of activities with respect to each particular country. And of course the rules differ according to the country concerned. The rules on Syria or North Korea are obviously a lot tougher than they are on, say, I don't know, the Congo. And for service providers, the simplest answer for them is to block IP addresses in some embargo countries. Up to them to decide which embargo countries should be blocked according to the specific nature of the restrictions on each country. And for denied parties, best practice, which is widely in place, I would hope, is that you establish a robust routine screening process to ensure that no customer, no supplier, no business partner, no user, no one with access to your technology appears on any of the sanctions lists as a denied party or especially designated national. And to the extent that you can, within a sort of reasonable risk-based procedures, look out for ownership and control, because the entity you're dealing with may not be listed if they are owned or controlled by an entity that is listed. For export controls, as I mentioned, updated UK government guidance is in hand. The current guidance, I should say, dates from 2010, so it's way overdue an update. And the government does hope to publish it by the end of the year. There is some helpful, I think, exchange with industry on the terms of the guidance. And I think probably it's true to say the main issue of debate is the use of end-to-end encryption in protecting the controlled information, controlled technology when it is uploaded overseas. So the UK guidance currently refers to the need for effective measures to prevent access, but it doesn't specify exactly what they are. Whereas, as I mentioned, the US has already gone some way towards, in fact, a long way towards defining minimum encryption standards and other requirements. And if those requirements are met, then under the US rules, both ITAR and EAR, they consider that the transfer is not, or does not constitute an export, and therefore would not require a license or other authorization. And the Netherlands, a year or so ago, it published some guidance specifying the requirement for encryption, use of only private clouds, and a risk identification and management system for the use of cloud systems when, as they apply to controlled technology. So other countries are moving along. I mentioned also Australia. They too have developed some rules which again are somewhat different. Germany has some other rules which are also slightly different. So I think it's high time the regulators got together and clarified these things. And I think, to be honest, from my personal view, the US standard sets a reasonable and clear set of rules. So for the meantime, and some sort of basics to follow would be to establish clearly robust procedures to identify and label anything that's controlled as software and technology. Ideally, you should do that anyway, whether you use the cloud or not. There need to be a robust procedure to control access to that software and technology by anyone who is located outside the UK, including members of the same company. And if using the cloud, negotiate contractors with the cloud service providers, which do a whole range of things. I'm not going to read all of these out, but just very briefly, ideally you should restrict the routing and storage locations if necessary. Not so important with the UK rules at the moment, but the US rules certainly do prohibit controlled items from being sent to or through sanctioned countries. Restrict access, including by systems administrators. And as I currently read them, the licensing requirement includes unintentional access to controlled technology, even if it's by a systems administrator, if they happen to be located overseas. So an administrator working for the cloud service provider who intentionally or unintentionally opened up the technology and was able to read it on Claire would require a license to do so. Restrict copying and require all copies to be deleted when the service is ended. Give yourself a right to audit the provider's compliance. Oblige the provider to notify you promptly of any suspected breaches. And do define the respective responsibilities of the parties for export compliance. Now, some very basics. Apologies to those of you who already know about export licensing, but just to give you some obvious headlines, that if you do need an export license, the first step is to check if an open general export license is available, since they often are in the UK and are much the simplest. If you do have a license and you use it, you're going to need to keep records, and keeping records of intangible transfers, and particularly transfers over the cloud, can be quite challenging. So you need to work out a way to do that in order to maintain the record requirement. Note that you may need some formal undertakings from end users or consignees as part of the license condition. And note that if there are any modifications to the license software technology, a new license may be needed. So the license you apply for may be applicable only to particular software or technology that you have defined in your license application. And if you then come up with something different, you may need a new license to cover that. Now, on Brexit, as everyone knows, I hope the transition period will come to an end on 31st of December. Until then, the status quo continues. Quite frankly, whether or not there's, as they say, a deal or no deal, whether or not there's a UK-EU free trade agreement, is really unlikely to make much difference to the export licensing issues that I've just described. As far as military items go, they're already controlled on a national basis. They're already controlled on the basis of UK law. So there will not be significant changes. For dual use, at the end of the transition period, the EU dual use regulation will be retained. That means it automatically turns itself into UK law. And so at least initially, the law will remain the same as it does now. But things could change. So on the dual use front, just to explain briefly, if you're moving something from the UK to the EU that's dual use, you need to register for the UK's Open General License for the EU. This is very straightforward, and that covers all dual use items. If you're moving something from the EU to the UK, the equivalent is to register for the General Export Authorization 001, and that already covers exports from the EU to the US, Canada, Switzerland, etc. They've added the UK, so if you're already registered for that, then your UK is covered. If you're moving things from the EU or the UK to a third country, it's important to note that existing UK licenses will no longer be valid for export from an EU member state and vice versa. So, for example, if you're using Republic of Ireland licenses to export from the UK, they won't be valid on the 1st of January. You'll need to get a UK license to do that. And next subject, and very much in the news today, movements between GB and Northern Ireland. So I would be extraordinarily surprised if any license was required for exports from GB to Northern Ireland. I just cannot see that happening. But there's still some question, as you'll be aware, over the exact requirements for movements from Northern Ireland to the GB. Whether that would include export licensing, it's very hard to imagine, but we'll see how that develops. I'm not going to stick my neck out on that subject. US licensing, I mentioned earlier, but it's important to be aware, if you're not already, that US export controls continue to apply to transfers, not only out of, but also within the United Kingdom. And the particular items to look out for are US origin, military and dual use items, non-US origin items that contain any US origin ITAR content, military ITAR content, or a de minimis level of US origin dual use content, and direct products of US origin technology. So if you're acquiring or developing items which might be subject to US export controls, ideally you need to ensure that the supplier of the US origin item provides details to you of what US controls apply, and put in all the necessary measures to ensure that you meet the US requirements. So finally, to wrap up, just to give you some headlines to take away, fairly obvious points, I hope. Controls apply, as I've said, to military and dual use software and technology with certain exemptions, public domain, basic scientific research. Sanctions apply to embargoed countries and designated persons, including individuals and entities. The use of cloud-based storage for controlled items, in principle, requires no license. But a license is required if controlled items are sent or made available to any person outside the UK, and that includes UK staff who are travelling overseas. And the UK requirements to prevent items from being made available to a person overseas are not wholly clear. Encryption in itself is not necessarily sufficient, and you need to have some contractual provisions as well. Let's hope that by the end of the year, we'll have more clarity from the government. And as I just said, do be alert to US controls that could continue to apply to US origin items and even to items made in the UK but using US content. Right, that's the end of that. So let me pass you on back to Will for another poll before we move on to questions. William, over to you.
Thank you, Richard. And as you can see, we have one last poll. This is one we do at all of our webinars at the moment, just to track business readiness for changes to EU trade post-transition. The options range from very prepared to not at all prepared, and there's a not sure as well. Just a quick note, we have sent in an email during this webinar from Brinley, just referring to the last question I asked actually, which was about what constitutes an electronic transfer abroad. He sent through the government advice, which includes this bit here where it says certain electronic equipment other than the telephone would of course also permit forms of oral communication such as video conferencing. Where communication by such means is purely oral, the rule which applies to telephone transfers will apply, namely that the transfers will be subject to control only where they involve reading out the contents, whether in part or whole of a document containing controlled technology, or describing its content in such a way as to achieve substantially the same results. The filming of documents or papers containing controlled technology, including by video phone, by sending by electronic means, would also require a license. So that's some useful kind of detail there. I can send through the link to that to everyone after this webinar. So I'm just going to give you a few more seconds to answer that poll before closing it and going into the Q&A. I shall close it now. So here are the results. 54% quite prepared, 19% very prepared. Now this probably tallies with the fact that I imagine our audience is slightly more captive in terms of international trade than the broader business community at large, but encouraging nonetheless to see that people following our webinars are prepared. Sterling stuff. Anyway, if we move on to the next slide now, and you will see how you can ask questions during the Q&A part of the webinar. So please feel free to ask questions using the control panel to the right-hand side of your screen. The first question we've had was from Ian, who's asked, what is the UK industry position on the emailing of US-controlled technical data?
Okay, yeah, thanks, William, and thanks, Ian, for the question. So I take it you're talking about emailing US-controlled data out of the UK. So it's already been received in the UK. So if you're going to email that out of the UK, then I think what I just described, I hope, would continue to apply. So the US licensing controls would still apply to it because it's US controlled data. So you may need you certainly need US authorization in the form of a license or a license exemption. And because it's US controlled data, it's likely to be UK controlled as well. That needs to be checked independently because the controls are slightly different. But by and large, if it's US controlled, it will also be UK controlled, and therefore it would need a license as well. Okay, William, I think that completes that question.
Actually, I've got a comment on that because some issues have arisen recently where technology that is not controlled under the US regulations in the UK is controlled under the UK regulations. So when it was re-exported, it would still come under the UK regulations and would need an export license, even though the US export license didn't apply. So as Richard says, you have to check the two independently. They're a good indication, but they're not definitive.
Yeah, thanks for that, Roger. Yeah, that's very important.
Thank you both. Another question we had in from Chris is in reference to the next generation in software-defined networking, SDN and SD-WAN. He asked, do you see legislative changes specific to this new technology?
Yeah, well, thanks for the question, Chris. It's hard to predict exactly how legislation or regulations will go. The legislation is constantly having to adapt to new technology. Generally, the adaptation to new technology happens not through, if you like, new legislation, but through updates to the control lists. So the control lists already take account of various elements of new technology, albeit not those ones. And so one would expect the experts who meet on a regular basis in the export control regimes to consider these issues and whether or not new additions to the control list or adaptations to the control regulations are required. I think in the meantime, I think the best one can say is that the broad principles that I've just laid out in terms of the controls applying based on the location of the recipient and not the location of the data will continue to apply whatever the software or cloud service that was being used at the time. But we'll have to see how that develops. I must say, I have to admit too that I think it's a considerable struggle for the regulators to keep up with the pace of change in technology. And I think that's sort of evidenced by the position we find ourselves in today, whereby, you know, the guidance we're working on is dated 2010, and here we are 10 years on, and the world is a very different place, as we can see. And you know, I don't blame my former colleagues amongst the regulators in struggling to keep up with all of this, but I think regulators as a whole and the international system is going to need to become more nimble if they're going to meet the twin objectives of preventing control technology from falling into the wrong hands on the one hand, but also facilitating legitimate commercial business on the other. Continuing that balance is getting more difficult by the day.
Thank you, Richard. A couple of questions on end-to-end encryption. So one question from Daniel he says, controls and data relating to encryption include control of the encryption keys. Some service providers insist on retention of the keys, which effectively prohibits their use of controlled data. Are the service providers, in your opinion, up to speed on the controls around controlled data? And Sinead has also asked, is it your opinion that UK guidance will clarify end-to-end encryption prevents inadvertent access?
Well, to answer the second question first, yes, I certainly hope that it will be clarified. That is the push from industry, if you like, that I think that the first drafts they've seen are still not sufficiently clear, certainly not as clear as the US or the Netherlands or some other countries have been. So UK industry is pushing hard to get that clarity because unless we've got that, and particularly on end-to-end encryption, it's going to continue to remain somewhat vague. People will be unsure of their precise obligations. With respect to systems administrators and providers, it's a very good question. And again, this is something that is trying to be addressed in the guidance. As I currently read it, and I think what probably is going to have to be the outcome, is that the systems provider and systems administrator are going to, in effect, be subject to the same obligations as users and as everyone else. So, as I think I said in the presentation, if it's the case that a systems administrator sitting outside of the UK could have access to the technical data, to the technology, unencrypted, then there would be a licensable requirement. They would need a license for that. So they have the decryption key and they're able to access that technology outside of the UK then they'll need a license to do so. I can't see that we can exempt them in any practicable way, but that needs to be worked through because it's certainly a question that keeps coming up.
Richard, if therefore a user needs to know from the cloud provider where the cloud data will be accessed from in order to meet those licensing requirements, do they need to know where the cloud itself is? In other words, in which country it's located?
Yeah, according to the current UK guidance, I think the answer is no, Roger. It's irrespective of where the actual server sits. So the server can be at the North Pole or wherever. It really doesn't matter where the server is. The issue is, where is the recipient? What is the location of the person who is reading it? So that's currently the rule. As I mentioned, there's a distinction there with the US, where the US has a requirement that controlled data may not be routed through or stored in a country subject to a US embargo. So that would put some controls on exactly where the servers are located. But for the UK, that doesn't apply at the moment. So I think the location of the servers currently is irrelevant.
But if there was a situation where the cloud was located in a country which hasn't clarified whether data stored on that server would require an export license if exported from that country, then is there a danger that by storing data on that cloud, you might need an export license from that country or inadvertently be making exports without the required license?
Yes, absolutely. As I think I said in the presentation, there's the UK rules, which would not give you a problem in that respect, but there's the local export control rules, and they need to be taken into account too. You're absolutely right. If something is stored on a server located in country X, if accessing that, if then moving that data, even in encrypted form, out of country X requires a license from country X, then you need to be aware of that. And again, it's not wholly clear. There isn't a sort of a published list of countries that have accepted that that would not be a licensable export, but something that it would be useful to put together. But for the time being, it remains somewhat unclear. And that's another good reason why in the contract with the service provider, it's a good idea to get clarity on where the servers and so forth are located.
Thank you.
Thanks.
Thank you, Richard, and thank you, Roger, as well. A question in from Ben, who's asked, in relation to nuclear technology, is your view that the storing of information on overseas servers will be the same as other areas of the dual use list, NLR, or do you envisage that licenses will be required to solely store due to relating to the nuclear industry?
Well, I think the main difference with nuclear items is that the definitions of what is technology are tougher. But once it falls within the definition of controlled technology, then the same rules would apply, as far as I'm aware, subject to correction. So if it's controlled technology, whether that's nuclear or anything else, the same set of rules would apply, but it's more likely to be controlled if it's nuclear than if it's dual use, other forms of dual use. So for that, you need to look rather carefully at the dual use list and the definitions that are given there to provide guidance as to whether a nuclear item is indeed controlled. And of course, the exemptions don't apply to nuclear technology in quite the same way either. So again, there's a greater likelihood of nuclear technology being restricted.
Thank you. I'll do a couple more questions. And a question from another Daniel, who's asked, cloud service providers often have follow the sun support based out of many countries. How do you manage the compliance for potential access to the controlled data?
Sorry, William, could you just repeat that again? Yeah.
Oh, William, you've gone quiet.
Oh, William?
Sorry, I was back on mute. So yeah, Daniel had asked, cloud service providers often have follow the sun support based out of many countries. how do you manage compliance in these different countries for potential access to the controlled data?
Okay, well, I think as far as the service provider goes, as I mentioned, you need to have some quite specific requirements in their contract, in your contract with them, that would ensure that your requirements are met, and that you have confidence that whatever arrangements the provider may have will be sufficient to meet your requirements. So that will be covered in the contract, and what the provider does overseas or around the world is going to have to follow from the requirements spelled out in the contract. As far as you, the user, are concerned, you need to ensure, as a sort of basic starting point, if you like, that you have control of everything that you upload onto that cloud platform, and that only if you say so can anyone else access it. So access to that information uploaded onto that platform has to be under your control. And there can be no two ways about that. So it's got to be up to you before anyone else has access to it, including systems administrators and so forth, because you have ultimately responsibility for who has access to it. So it's only in your interest to ensure that you may retain that control. So you retain it through contractual arrangements with the provider and through your own control of who you grant access it to. And if you don't grant access, you don't take a positive action to grant access to someone, then the default position is that there is no such access. It needs to be a positive step by your part, on your part, to grant such access. And when you grant such access, then you need to consider, do I need a license in order to do this? I hope that answers the question.
I hope so too, thank you. I'll do one question on software as a service. We've had a couple of people ask. Sinead asked, regarding software as a service, where can I find explicit language that clarifies the SaaS provider is not an exporter?
Well, this is partly going to be addressed in the new guidance. I'm not sure that it is actually spelled out in the existing guidance, but it's widely understood because it's clear that controls apply to executable software. If you're not actually downloading software, then where's the control? What have you got? All you're doing is you're using something, but you're not actually downloading executable software. But no, I think it's a good question. I'm not sure that I can point you to specific wording that would spell it out in those terms. I think both the US, the Netherlands, and even Japan, I think, have spelt it out. And as I say, I think it's widely understood that that's the way it works in the UK. But I think you're probably right to point out there's still some ambiguity over these things because it's not put down in black and white in the UK.
Thank you. And I'll do one last question. I know you touched on Brexit at the end, but here's a scenario. So Jim has said he works for a German company. We import and supply military goods to UK entities under license. After Brexit, will our engineers require a license to share information with our German colleagues electronically?
I think the short answer to that is yes. If that technology is moving from the UK to Germany and vice versa, you'll need licenses in both directions. So if it's going from the UK to Germany, you need to sign up or register for that UK Open General license for the EU. And if it's coming back from Germany to the UK, then you need to be registered for the EU General Export Authorization 001. And those licenses will cover those transfers in both directions. Or in each direction, I should say.
Great. Well, on that note, we'll wrap up, I think. So thank you very much to Richard and Roger for the answers. I hope everyone has found that useful. And thank you again, Richard, for the presentation. That was an excellent and very thorough presentation on what can be, I'm sure, quite a technical topic. On the final slide, just a reminder that by joining the Institute's export control profession, you get access to a support network of people working in similar roles, a wealth of useful industry-specific resources and events such as this one, regular updates on compliance matters globally, and a continuing professional development program to ensure you can meet your obligations and maintain the highest standards in international trade. To find out more, please visit www.exportcontrolprofession.co.uk or get in touch with us at institute@export.org.uk. For now, though, thank you all for tuning in today. We hope you found the session useful. Please do take the exit survey to let us know what you thought of today's webinar and to suggest any future topics we could cover in the future. But for now, goodbye everyone and stay safe.
Thank you very much.
Bye-bye.
Cheerio. Bye.